Hello and welcome to the show. Let's get right into it. About 2 weeks ago, I did a video on a Detroit man who abducted a woman and did horrific acts. I believe it is titled A House of Horror. Please go check that video out because this video has to do with him as well as how judges do not have to follow sentencing guidelines. This judge put it on him. And for some reason, I'm thinking Judge Submarinian might do the same. Judge Submarinian might be like, look at here, Diddy, I don't care what the jury said. This is what I came up with. Take a listen to the judge.
I had an opportunity to listen to disturbing testimony over the course of 7 days or so. I will say this, I've been in criminal law for nearly 30 years, and it's one of the most disturbing cases that I have ever had an opportunity to either sit as a jurist or as an attorney. If the court would note the following: if this was a case where a young lady who assumed that you were her friend, believed you to her own ultimate certainly to her own ultimate untimely, unnecessary very eventful and disturbing rape. We don't say rape, we call it criminal sexual conduct, but this is what it was. And it was something that she certainly did not anticipate, that would come from someone that she called a friend that she had met at school some years earlier, in college, someone that she trusted. And sir, this young lady was subjected to this because you used your friendship with her to lure her to your house of horrors on the premise that she was going to be interviewed by a pastor, unbeknownst to whomever pastored the church that was across the street. And she was going to be interviewed at the home where you stayed, where all of the events occurred that you alleged, and you told her, and she believed you, was going to be renovated as an office building. She believed you so much so that she exchanged texts and other communications with you because she wanted and needed a job to work with children, which was her love. She was a school teacher, and it was a job to supplement her income as a substitute teacher. She believed you. And she arrived there on that day by the way of either Uber or Lyft, only to have her life turned upside down by someone she called friend. Mr. Payne, your conduct, your behavior, your deceit on that day, in those 2 days and one morning, was the kind of things that makes grandmothers clutch their pearls. Grandpas grab their granddaughters and hold them tight, not wanting the world to bruise them. It's the kind of behavior that makes mothers become helicopter mothers. And every place their daughters or their children go, they're always there, flying in and flying over, and not so fearful that they don't let their children out of their sight for more than a few hours, and always making calls, and their children are just huddled over because of this kind of behavior. Your conduct on those 2+ days, Mr. Payne, is the kind of things that makes fathers lose sleep over, the kind that makes fathers become vigilantes over, the kind that makes fathers worry about whether their daughter is going to come home safely from social events, go to school and not be accosted. The kind of things that make fathers worry from the cradle to the grave. Your behavior was the kind of thing that makes young women afraid to go outside, to socialize with other people, and ultimately to not trust men. Your behavior on those 2 days, your deceit that led to all of those incidents that were testified to from that stand that the jury believed and found you guilty of. Your behavior is the kind of things that makes legislators scramble to keep up with the laws that intended to deter people from committing such atrocities, and making the consequences when they do violate women the way that you do, makes those legislators come up with new laws and extend time limits for serving the consequences in correctional institutions. Your behavior was unseemly, unnecessary, untimely for Miss Garrick, and ultimately brings us to this stage at your very young age, because you chose to be deceitful to bring to fruition your fantasies. The testimony didn't support, nor did the jury buy that it was her fantasy, but it was your sexual fantasy that resulted in what happened to Miss Garrett during those 2 days of living hell that she had to endure at that nasty house, that house full of feces, the scrap furniture, clothing, debris, all around that house. You subjected her to that, and she didn't deserve that. Your behavior is the kind of thing that makes judges scratch their heads in disbelief and lose precious sleep, contemplating what kind of sentence could I fashion that would or sometimes even inadequately, but adequately in this case, address the egregious, immoral, savage, sadistic, sexual deviant behavior that you subjected Miss Garrett to. And that brings us to the sentencing, sir, to the actual sentencing that I have contemplated for a few days, and I thought I'd listen to what Miss Garrett had to say, and I'd hear what she said via the prosecutor. We've gone over the guidelines, and here you are and here I am, sir. And it's not something that I relish doing, but the law requires a response to the kind of behavior that the jury said that you were guilty of. Can you stand, please, sir? You can have a seat. I need to read some law. I'm a judge who certainly, the foundation of what I do is based on the law. I'm telling you now that I'm going to depart from the sentencing guideline. I do not believe that the sentencing guidelines adequately address some of the seriousness of the circumstances that surrounded the offense on those 2 days of living hell for Miss Garrett. The seriousness of those offenses, all of the sexual toys that you used to violate Miss Garrett, the circumstances of being locked in a room, her bag taken that had her phone in it, and unable to call loved ones or anyone to tell where she was, the circumstances of the degradation that you subjected her to, the penetrations. She testified that she was a virgin, that she hadn't had sexual relationships with a man, and you took that from her. And so the court doesn't believe that the guidelines adequately address the seriousness of the offense that you committed. As well, court believes that the fact that Miss Garrett considered you a friend is another reason that this court is departing from the sentencing guidelines. You had a relationship with her that was established in school. You didn't stick it out for more than 1 year, but she stuck it out, became a school teacher because she wanted to give something back. And you used that friendship as a hook in her mouth to get her into a compromising position where you took pictures, you had an X under a chair where you wanted her to sit so that you could live out your unseemly fantasies. And you did that. She didn't enjoy it. You did that. She vomited. She retched. She didn't want to be there, and yet you subjected her to that where she had no way of getting out. And you did that, and you had the opportunity to do it because you said you were a friend, and she believed you. And I note that this friend that you that she thought you were, the same friend, had the nerve to tell her that you are the first one who fell for my ruse. Weren't your exact words, but something to that effect, indicating that to this court that perhaps you had tried it before. There was testimony. And that is another reason why I'm departing from the guidelines. This court also believes that the guidelines don't adequately address the psychological injury to Miss Garrett. Yes, the court hasn't heard from Miss Garrett, but all indications from the pre-sentence investigation report and certainly from the prosecutor is that the victim is undergoing psychological counseling that this court can only surmise that will make generous attempts to assuage the hurt, the fear, the anguish that she feels, but sometimes that psychological injuries extend for the rest of their lives and make them wary of people, wary of men, wary of social settings and situations where they might otherwise feel at ease. And so that's another reason why the court is going to depart from the guidelines. The severe impact of that assault on Miss Garrett, 2 days assault, and leaving her while you went over to your boy's house to wash your clothes, do a little laundry, and play more video games. And the testimony was that you played video games during this 2-day sexual fantasy of yours. You, while she lay on a bed with a mattress that's on bricks, that you sat over the side near the door, guarding the door, because you had the other the guns, the shotguns, the instruments to confine her and put her in fear of being harmed. You sat by the door playing video games because you thought the whole thing was a game. You thought that entire weekend of hell was a party or a fun. It's something that you made up in your mind, and you decided to include Miss Garrett. And so, sir, I am going to depart from the guidelines for those reasons, because I do not think that the guidelines adequately address those things that I have already indicated for the record. It is the sentence of this court, sir. Now you can stand. It is the sentence of this court that you be placed in the custody of the Michigan Department of Corrections to serve a period of, on counts 1, 2, 3, 4, and 5, a period of 25 to 50 years on each of those counts. And those counts, sir, will run concurrent to each other. Counts 1 through 5, 25 through 50 to run concurrent. However, as to count 6, kidnapping, it is the sentence of this court that you also serve a period of time of 25 to 50 years on count 6, kidnapping, to run consecutive to the 25 to 50 years on counts 1 through 5. One moment. And the court is allowed to do that by law, and my reason for doing that is, sir, some of the same reasons that I certainly use and believe undergird my decision to go outside of the guidelines, depart from the guidelines, but also, sir, there was a statement that you made, and certainly the behavior that followed it, according to Miss Garrett, that she was going to be your sex slave for as long as you desire. And in addition to the things that I've already noted for the record, that your behavior showed exactly that. You left to go do laundry. And rather than, if it's a sexual fantasy that she shared, rather than let her go, it's her testimony that you locked her in. And when the police got there, the evidence tech and the testimony from the police was that the door was fitted with a lock, whether it was locked then or not, because there had been a time delay between the time that that Miss Garrett was able to jump down off of 2 stories to run to her safety, first to Kentucky Fried Chicken and then seeing someone close. It is this court's opinion that those words and your conduct and how you left her suggested that you had intended to use her and abuse her for as long as you desired. And that is the reason why I am making those the counts that I indicated consecutive to one another. Count 6, 25 to 50 years consecutive to count the 25 to 50 on counts 1 through 5. And finally, as to count 7, assault with intent to do great bodily harm less than murder or by strangulation. It is the sentence of this court that you serve 5 to 10 years in the Michigan Department of Corrections, and the 5 to 10 years, sir, will be concurrent to counts 1 through 5. In addition, you must not live in a residence where any individual age 17 or under stays or is cared for. You must not provide care for any individual age 17 or under. You must, I did see that you had registered, but you must register the criminal sexual conduct in the first degree is a tier 3, it's classified as a tier 3 crime with a lifetime duration of being registering with the Sex Offenders Registration Act. Unfortunately, the probation didn't add. Is there something else that goes along with that?
Judge, I did just see that it does not have the lifetime electronic monitoring should defendant be paroled.
All right, and there will be lifetime monitoring under the Sexual Offenders Registration Act once you are, if and when you are paroled. You must pay crime victims assessment in the amount of $130. You must pay court costs of $1,300. And lastly, you must pay $68 state costs. Those are the terms of conditions of your sentence, sir. The court has concluded this. Is there anything else from the lawyers?
What are your appellate rights?
All right, there are no appellate rights as the jury found him guilty. There's appellate rights that are certainly appealed as of right, but none that I read. All right, state costs of $68 times 7. I called my own probation agent late last night because whomever created this report was missing something. How much is that total? $476 state cost. One moment. Thank you.
So, as we see here, in general, judges don't have to strictly follow sentencing guidelines, but they are expected to consider them. While the guidelines are often advisory rather than mandatory, judges are generally required to explain any significant departures from them, as this judge certainly did very well. I'm sure that the defendant understood every word that the judge said. If he did not, I'm sure his lawyer will explain it to him. And if Judge Submarinian decides to stray away from the guidelines, I'm sure he will have his reasons ready why he has made the choice he made. I thank you all for watching. Don't forget to like, share, and subscribe, and comment.